Good morning, everyone, and thank you for joining this webinar. We're just going to hold for a few moments just whilst people join, but we'll get started very shortly. Okay, I can see the numbers going up there and just levelling off. So welcome to you all for our annual update for schools this morning. My name is Oliver Daniels and I'm a partner in our education team. And it's great to see so many familiar names on the delegate list this morning and a few new ones joining us as well. We hope that you're all keeping well and that term has gone smoothly for you so far. As many of you will know, this is a session that we run annually for schools, covering key legal issues. And looking back at our annual update in October 2020, it has continued to be a period of unprecedented challenges for those working within the sector. And we hope that by putting on sessions like this, we're able to support you in a small way in addressing and dealing with those challenges. And with that in mind, we have a fairly packed programme for you this morning. We're going to start with our traditional employment law update. We will then cover key issues for schools in relation to VAT and construction works before our final session in which we'll look at commercial highlights with tips for schools operating in the year ahead. After each speaking slot, we hope to have a few minutes to cover some questions, so please do use the Q&A function at the bottom of your screen to type in questions as we go, and we'll try to answer as many as we can. Any that we don't get to, or that are a bit too complicated to answer this morning, we will follow up separately with you after the event. So without further ado, I'm delighted to be joined by Rachel Parkin and Heather Stickland for our first session, which is our employment law update. Rachel is a partner in our education team and will be known to many of you. She's an employment specialist, as is Heather, who's a senior associate within the team, both of whom work exclusively with schools, so are really immersed in the sorts of issues that you deal with on a day-to-day basis. So over to Rachel.
Thanks, Oliver. Good morning, everyone. Next slide, please, Tom. Over the next 25 minutes or so, Oliver, Heather and I are looking to provide you with a general employment update, and hopefully it will be a useful reminder of some of the recent legislative developments in the area. So in terms of what we're proposing to cover today, I'm going to be taking you through a few of the frequently asked questions we're receiving regarding COVID vaccinations. Ollie is going to be looking at some recent case law, and Heather is going to finish off with giving us a bit of an idea as to some important employment law developments on the horizon. As Ollie mentioned, please do ask questions via the Q&A function at the bottom of your screen. We may try and pick some of these up as we go along, but if not, we hope we have some time at the end to discuss as many as we can. Next slide, please. So the government hasn't legislated for the COVID vaccine to be mandatory within the education sector. So as a result, schools are facing a number of difficult and untested employment law issues in relation to COVID-19. One of the key questions we're being asked at the moment is whether a school can insist that staff are vaccinated against COVID. So as the government hasn't legislated for it to be mandatory within the sector, on balance, it does remain a risk for schools to insist on staff receiving the vaccination, even in an environment where, as we all know, there's often very close contact. Social distancing can be difficult, particularly in the younger years. The key legal issues with mandating the vaccine are, of course, the risks of dismissing employees who don't comply. And if they've got over 2 years service, of course, there's the unfair dismissal risks, and also the potential discrimination claims from employees with a protected characteristic. While in some cases you may be able to justify a requirement for mandatory vaccination, this could prove challenging where essentially you've got less effective and less potentially discriminatory methods available. So regular testing, for example, social distancing, and in some cases, of course, home working may be possible to reduce the health and safety risks in school. Current advice at the moment is that the vaccine is not a substitute for workplace COVID secure measures, and they must, of course, still be complied with. So given the legal issues, significant legal issues and risks associated with mandating a vaccination, we anticipate, and we've been advising schools and, to be honest, most other employers, to adopt an approach of encouraging staff and supporting staff to have the vaccine as opposed to insisting. Another question I'm often asked is whether a school needs to have a staff vaccination policy. It's not a legal requirement to have a policy for staff, and you might think instead that it's better to communicate via your usual means, so a staff update, or perhaps have some guidelines in place instead. But given the legal issues and the risks associated with the vaccination of staff, you could find that a policy is quite helpful. It could explain a school's stance on vaccination and, of course, the school's overall objective. You might find that it also assists in handling concerns that could arise regarding vaccinated and unvaccinated staff. It might answer some of the sort of frequently asked questions you might receive from staff. I should probably mention that we have produced a template staff vaccination policy for the ISBA. So it should be in the ISBA library now, that provides you with some guidance as well, but also allows you to tailor that template to suit your own circumstances. Vaccination status is another area which we're being asked about quite regularly, and whether a school can require its employees to share details about their own vaccination status. Essentially, many of the risks that I've mentioned associated with schools making the vaccine mandatory for staff will equally apply to any school requirement that staff have to disclose their vaccination status. Law and government guidance, unfortunately, don't currently require staff to provide that information. And so we would be open, or could be open, to challenge if we try and insist that staff share that information and they do not want to. We anticipate that schools are adopting, and as I say, we're recommending an approach of encouraging staff to share this personal data as opposed to insisting. The ICO guidance at the moment talks about, I think it needs to be updated if I'm honest, but at the moment it's published some advice on the collection of vaccination status data, which states that the sector in which you operate, the nature of the work that's carried out, and also the health and safety risks in the particular workplace will all be relevant in deciding whether you have a legitimate interest to record that vaccination status of your staff. The guidance does also give some examples about staff who are likely to come into contact with those infected with COVID at work, or who could pose a risk to clinically vulnerable individuals. But in the absence of further guidance from the ICO, our view is that these examples could make it more likely that the collection and processing of vaccination status can be justified in schools, particularly in the case of situations where you've got staff who are working regularly with colleagues, for example, who were perhaps previously considered clinically extremely vulnerable, or indeed who have received personal advice from their specialist or clinician on additional precautions that they might need to take. Ultimately, the key consideration needs to be whether a school needs that information, whether it needs to take account of vaccination status in determining the appropriate measures that they need to take. You might then be able to justify asking for vaccination status, and of course you would need to document your rationale for that. But of course, if actually it doesn't have, the vaccination status doesn't have a practical effect on the measures that you're taking, it's unlikely to be justifiable to request and process that data. So all of this should form part of your ongoing risk assessments. So leading on from this, we've had a few clients ask whether schools should keep social distancing and other measures in place for anyone that we know that's unvaccinated. But of course, it remains your obligation to ensure the health and safety of all employees, those vaccinated as well as those who are not vaccinated. And whilst the vaccine has meant that we've been able to reduce measures in line with the government guidance, it's not advisable to obviously remove them entirely, especially if there are some staff who remain unvaccinated. Again, this just needs to be considered as part of the school's overall risk assessment. Of course, you might be also worried about differentiating between employees based upon vaccination status, which could, of course, affect staff morale, but also could create risks from a discrimination perspective as well. So you will need to balance the risks of implementing such measures against, of course, the disruption that could result if an unvaccinated teacher has to self-isolate, for example. Moreover, in respect of any discrimination risks, it could be possible to justify requiring unvaccinated staff to adhere to additional measures as a proportionate means of achieving a legitimate aim, but it would need to be assessed on a case-by-case basis. And finally, I thought it would be also useful to consider about payment, because that's something that has cropped up quite a few times recently, and what schools should be paying unvaccinated staff who have to self-isolate in accordance with the government guidance because they've been in contact with someone with COVID-19. If the employee is able to work from home, then of course they would be entitled to usual pay. But if they are unable to work remotely, but are following the government guidance on self-isolation, they are as a minimum entitled still to statutory sick pay, and that's until the end of this self-isolation period. Now, the payment of contractual sick pay will depend upon the terms of your contract of employment and also relevant sick pay policy. So if, for example, the contract or policy provides that contractual sick pay is payable whenever SSP is payable, meaning that essentially the same eligibility criteria apply, then you would need to make payment in full where SSP is triggered by self-isolation, whether or not the employee is actually suffering any symptoms. In most cases, though, and most of the contracts we see, employees won't automatically be entitled to sick pay under a school sickness absence policy, but you will need to check the specific terms of your own contract and policy. Ordinarily, sick pay is based upon someone being unwell or unfit for work. Obviously, not quite the same if you're just self-isolating because you've been a close contact. And we don't anticipate offering sick pay in circumstances where somebody is not personally unwell, but obviously absent for public health reasons. That said, you might consider offering an entitlement to full pay, because it could assist, for example, in ensuring that employees do actually follow the track and trace guidance and remain at home and don't risk coming into school and spreading the virus. It is important to ensure generally that employees are treated as consistently as possible, but you will of course need to be mindful of and of course sympathetic to individual circumstances. I'm now going to pass you over to Oliver, who is going to talk to you about a few of the recent COVID-related employment cases.
Thanks, Rachel. And if we can have the next slide, please. So continuing with the theme of the pandemic, perhaps unsurprisingly, we've seen an increasing number of employment tribunal claims coming through the system relating to COVID-19. And I'm going to take a look now at some of the key themes that we're seeing, and importantly, the lessons that can be learned, particularly from the employer's perspective. We have, for example, seen a number of cases relating to employees who, due to the pandemic, have refused to return to work. And often those claims have been made in the context of a previously little used statutory right for employees to stay away from work or take other appropriate steps to protect themselves or others where they reasonably believe there are circumstances of serious or imminent danger. And it's been unclear how the employment tribunal would interpret that statutory right in the context of COVID-19. We've seen some contrasting decisions on this, but the general approach of the employment tribunals has been to require at least some evidence that the employer is failing to take proper precautions or clear evidence that there is a particular danger before an employee can be justified in refusing to attend work and benefit from the protection. In other words, the mere existence of the virus isn't enough to show that serious and imminent danger justifying a refusal to attend work. The wider circumstances of that refusal will be relevant, including the precautions that the employer has put in place to minimise the risk and the communications from the employee to the employer and vice versa. And that was reflected in the case of Rogers versus Leeds laser cutting, where the employer had implemented the government's workplace safety guidance and the employee hadn't, before leaving work, raised any particular concerns with his employer. And in that case, the employee was found not to have the right to absent himself from work, and therefore his dismissal for doing so was found to be fair. We've also seen in cases along this theme that the behaviour of either the employee or the employer does have an impact in terms of the tribunal's decision-making. For example, in the case of Montanaro versus Landsafe Limited, an employee found himself in Italy on annual leave when a lockdown was announced in Italy. The employee contacted his employer and asked for guidance on what he should do. The employer responded to say that he should await further instructions, so the employee stayed in Italy, didn't board his flight home, and continued to work from Italy remotely. But without further communication, sometime later, the employer wrote to dismiss the employee, sending the dismissal letter to his UK address, despite knowing that he was in Italy. The letter also referred to a disciplinary hearing that had never taken place and suggested that the employee had failed to contact his employer, which of course he had. So in that case, the tribunal took the view that the threat of COVID-19 was, in those circumstances, a serious and imminent danger, and that the employee had taken reasonable steps to protect himself, no doubt influenced by the employer's inappropriate behaviour. Of course, it's important to say that those decisions mainly concern events occurring during the first few months of the pandemic, and those are the cases and decisions that we're seeing now coming through from the Employment Tribunal, because there is a significant backlog in the system. And clearly much has changed since those circumstances arose. We have far greater knowledge and understanding of the virus. And of course, we have the vaccination programme, which significantly reduces the risk for many. As a result, it's quite likely that it's going to be much more difficult for an employee now to establish the serious and imminent danger test so as to justify a refusal to attend work. But it remains important in the context of that statutory protection and given those cases to ensure that you have appropriate health and safety measures in place and that you're communicating those effectively to your staff and communicating effectively with those staff who may express concern about the working environment. We've also seen cases relating to an employee's refusal to comply with their employer's health and safety rules. For example, in the case of Cubulis versus Kent Foods, a delivery driver was dismissed for refusing to wear a mask while in his lorry cab at a client site. The Employment Tribunal in that case found the dismissal to be fair, despite the official guidance at that time around mask wearing being that it was optional. And that approach supports the employer's right to enforce its own reasonable health and safety measures and, subject to legitimate exceptions, to expect that employees will comply. And this is something that we have seen in the context of schools over the course of the last 12 to 18 months, particularly in relation to mask wearing and social distancing. You may well have experienced issues in terms of members of staff pushing back against the restrictions that you're seeking to impose to protect staff. And again, this comes down to that clear communication with staff and identifying as part of your internal risk assessments that the measures that you consider to be reasonable to protect staff and pupils. Finally, one of the most difficult issues for employers has been dealing with those who fall within the clinically vulnerable category. There have only been a few cases on this, but it appears the employment tribunals are backing a cautious approach. For example, in the Prosser versus Community Gateway Association case, the Employment Tribunal found that there was no unlawful discrimination against a pregnant worker when she was sent home at the beginning of the pandemic and was told not to return until health and safety measures had been put in place. In fact, the tribunal went as far as commending the employer in that case for taking appropriate steps to protect both the employee and her unborn child. In Gibson versus Lothian Leisure, the Employment Tribunal found that a chef had been automatically unfairly dismissed when he refused to return to work, having raised concerns about the health and safety measures his employer had put in place, or the lack of, and the risk of infecting his extremely vulnerable father. And again, a case there of a situation where the employer's behaviour perhaps impacted and influenced the tribunal's decision, because when the employee raised concerns with his employer, he was allegedly told to essentially shut up and get on with it, which clearly wouldn't have gone down well with the Employment Tribunal. Again, the circumstances have changed somewhat since the facts of those cases. They do show, again, however, that employment tribunals are likely to respond more favourably to employers in these cases, where you're able to demonstrate a compassionate and measured approach in accordance with government guidance and having implemented appropriate health and safety measures. So what conclusions can we draw from these cases to date? It's clear that the decisions are very fact-specific, but I think the most important lessons so far appear to be about consulting with staff, updating risk assessments, implementing appropriate COVID-secure measures, and ensuring those measures are communicated to staff and properly enforced. All of the things that in our experience schools have been doing throughout this process. And in taking those steps, that should put you in a good position to address concerns raised by individual members of staff and any particularly contentious circumstances. But this does remain an area of uncertainty. We are continuing to see decisions come through. As I said, there's a significant backlog in the employment tribunal system, so there will be further decisions and cases that come through on this. So if you do have particularly difficult or complicated situations with employees relating to any of these themes, please do feel free to contact us and take advice. Okay, I'm now going to hand over to Heather, who's going to finish up by looking at what's coming on the horizon.
Thanks very much for that, Oliver. Can we get the next slide, please? So we're looking at what's coming up on the horizon from the employment law perspective. So the first point to flag is a case that's coming up to be heard by the Supreme Court on the 9th of November 2021. So that's Harper Trust and Brazel. So this is in relation to calculating holiday pay. So you may recall the facts on this one as it's been around in the system for a little while. So Mrs. Brazel is a visiting music teacher who works at a school run by the Harper Trust. And when this matter was heard by the Court of Appeal, they held that using the calculation method for holiday pay of a 12.07% calculation for a permanent member of staff who doesn't work through the whole year, so we've got a lot of clarifications there, is unlawful. So they said that in order to calculate holiday pay for part-year workers, at the time the holiday is to be taken, employers should identify a week's pay in accordance with the Employment Rights Act, and then multiply that figure by 5.6, which is the statutory entitlement that every employee has to holiday pay per year. So if the Harper Trust is going to be successful in its appeal at the Supreme Court, then the principle of prorating the 5.6 weeks holiday entitlement for those who work part of the year could be reinstated. However, if they're unsuccessful, then schools who are currently continuing to use the 12.07% multiplier will need to change their practices. So obviously we'll keep an eye on how that one's proceeding and keep you all updated from that perspective. Then we have a couple of consultations that we just wanted to bring to your attention. The first one in relation to flexible working. So this is often kind of referred to as flexible working becomes the default, which is probably quite a scary prospect initially for some employers when they hear it kind of spoken about like that. So a little while ago, and links back to the Queen's speech in 2019, the government promised a consultation on the proposal that flexible working becomes the default. And due to delays related to COVID, this consultation has only just commenced. So by way of background, the consultation notes that COVID-19 has required many of us to change how we work, and it's shifted the way that we think about flexible working. It notes that there's a greater recognition for the need for flexibility to balance work with other commitments. So for example, childcare, or looking after family members who are unwell. So they note that employers have had their eyes opened to what might be possible, and that this should be regarded as an opportunity. But by contrast, it does also recognise that this must be done in a way which recognises that remote working may not work well for everyone. And I think that we've noted with schools very often that flexible working just isn't really necessarily an option. But it's still really important, I think, to be aware of this consultation and potentially to contribute to it as well, if you have any kind of significant thoughts that you wanted to share. So the consultation sets out 5 proposals for reshaping the existing framework. So it states that the right to request flexible working should become a day one right rather than having to have a period of continuous service. It suggests making changes, if necessary, to the 8 business reasons for refusing a request to work flexibly. It requires the employer to suggest alternatives to the arrangement suggested by the employee if they're actually going to reject the original request. It looks at changing the administrative process underpinning the right to request flexible working. So that's in terms of the formalities that are currently associated with the current process. And it looks at raising awareness of the existing right of employees to request a temporary flexible working arrangement. So the consultation on flexible working closes on the 1st of December. And as I mentioned previously, you can contribute to that one. They can be submitted online or via email. So one to be aware of and to think about if you have any submissions that you'd like to make in relation to that. The other consultation, which has already taken place, relates to carers' leave. So in March 2020, the government opened the consultation on carers' leave. On its proposal to give employees who are also unpaid carers 1 week's additional unpaid leave a year. So in September last month, the government published a response to the consultation. So what they've come up with is to introduce a right for unpaid carers to take up to 1 week or 5 working days of unpaid leave per year. And this entitlement will apply in England, Wales and Scotland. So the government are trying to kind of put a more positive spin on this when employers kind of think of the costs associated with greater employee absence, and saying that, you know, employers will benefit in other ways, including greater employee loyalty, reduced staff turnover, increased productivity and enhanced reputation. So in terms of the details associated with the carers' leave, there will be eligibility criteria associated with that right to have the 5 working days unpaid leave. So it will be a day one right, so available to all employees regardless of how long they've worked for their employer. And it will rely upon the relationship of the employee with the person being cared for. And that relationship will broadly follow the definition of a dependent. So a dependent, when we're talking about parental leave and various kind of things along those lines. So it will follow that definition. And then it will also depend upon the person being cared for having a long-term care need. So that's defined as a long-term illness or injury. So it could be physical or mental. And a disability as defined under the Equality Act, or it's issues related to old age. There's slightly different situation in relation to anybody in a terminal kind of care position. But that's where we are in relation to the carers leave at the moment. We anticipate that we'll get a bit more detail around that when it is actually introduced via legislation. So that's it for now for On the Horizon, and I'll hand back to Oliver to see if we've got any questions.
Thanks, Heather. That's great. And plenty going on from an employment perspective, as you can see. I think we'll continue to see issues arising relating to COVID and vaccination programme. And the Brazil case, that will be a key decision for schools. We have had a few questions through. So I'm just staying with you, Heather, actually first. On the Brazil case, a question as to when we can expect a decision on that.
Yeah, so I think conventionally, you know, when the Supreme Court hears a matter, it will take them normally a number of months to hand down their judgment. So I think we'll be looking into probably early new year, really, in terms of getting the judgment on that. But obviously, as soon as we've got it, we'll get our bulletin out there.
Yeah, there's a significant backlog, isn't there? So yeah, watch this space for that one. One also for you, I think, Rachel, in terms of the vaccination programme, a question: can a school require that all new starters are vaccinated as a condition of their employment?
That's a good question. Well, I think it's likely to carry less risk than insisting that all staff are vaccinated, as new joiners, of course, won't have sufficient length of service to benefit from unfair dismissal protection. But the risks relating to potential discrimination claims from new joiners remain. So any candidates with protected characteristics would still apply. So we'd still need to give careful consideration if we wanted to do that. But as with the mandatory vaccination risks and everything else that I discussed earlier, in light of these risks and concerns, we anticipate that schools and other employers will probably just adopt an approach, as I said, of supporting and encouraging new joiners to have the vaccine rather than actually requiring it as a condition of employment, unless, of course, there was some sort of compelling reason why we needed to do that.
Yeah, absolutely. And I think if there's any school that's looking to take a different approach, it's worth taking some advice, isn't it, given the risks that you've identified? Yeah. Perfect. Thank you, Rachel and Heather. We're going to move on now to our next session this morning, which is looking at key issues for schools relating to VAT and construction works. And I'm delighted to introduce my colleagues Colin Jones and Sarah Woodhall this morning. Colin is a partner in our construction team, and Sarah is also a partner and the head of our tax team. So over to you, Sarah.
Thanks very much, Ollie. Well, I'm going to talk about some important themes for tax in the context of construction and schools. There is a lot that we could talk about, so the main focus will be on VAT, but we'll talk about a couple of other taxes also, just very lightly. And if you have any questions, please do put them in the chat box. It's really important that we consider, if we could go on to the first slide, please, the question of charitable purpose. It's fundamental to the tax treatment that schools can or cannot achieve. And therefore, I think it's quite important to emphasize those features that we need to achieve and achieve over time in order to retain that charitable status. An institution has to be established for charitable purposes only, and additionally, a charitable purpose is for the public benefit and a purpose which includes advances in education. So all of the time, when I'm advising schools, we need to just double check that both of those criteria are continuing to be met in relation to the aspect of their activity that we're advising about. Moving on to the next slide, the public benefit test, unhelpfully perhaps, doesn't have a statutory definition. It's an ordinary definition, a definition that you or I might use in ordinary life that applies. But additionally, foundations, voluntary, academy and free schools, those outside of the control of local authorities, do fall within the meaning of charities. And again, that's very detailed, but nonetheless, it's important because you need to fall within the definition of charity to enjoy some of the benefits that I'm going to talk about. If you move to the next slide. So the fundamental advantage when it comes to construction and schools is that provided the construction and the school meets certain criteria, then there is an opportunity to zero rate the construction costs. So zero rating, you remain liable for VAT. You have to submit VAT returns in the ordinary way, but the zero rate means that the rate of VAT that applies is, of course, 0%, and therefore nothing becomes payable. But the conditions for achieving zero rating are not necessarily straightforward. So when it relates to the construction of a new building, if you're a school, it's important that that new building is intended for use solely as a relevant charitable purpose. And additionally, if you're converting a non-residential building, the purpose or your intention has also to be solely for its use as a relevant charitable purpose, nothing extra. So if we move on to the next slide, the zero rating applies not only to the construction itself, but also to supplies in the course of the construction. So again, if it's intended for use solely for a relevant charitable purpose, supplies in the course of the construction can be zero rated, and also any services related to the construction. So there are some specific exemptions that it's important to be aware of, and specific exclusions include the costs of architects, surveyors, people acting in the capacity as a consultant, and also those who are supervising. So it's important to recognize before you make those investments that they will attract VAT, and also that when you come to make returns, that you need to make provision to ensure that you do not apply the zero rate in relation to those aspects of service. It's very unfortunate if you're an architect or a surveyor, and it may be that schools need to think about the extent to which or the amount in which they invest in those areas because of the associated additional cost of the full tax exposure, the full VAT exposure. If you look at the next slide, there's also provision. I've been touched on a bit of the law, and you know that intention to use as a charitable purpose is very important. But there is some flexibility and there is some softness where part of a building is intended for use solely for a relevant charitable purpose, but a part isn't. Then it is possible to do an apportionment. So it doesn't disqualify the building as a whole, there is a pro rata apportionment that can be done to ensure that that element or that part that is being used solely for a relevant charitable purpose does attract the zero rate, and those parts that aren't will attract VAT at the standard rate. And again, that's a very simple computation, and expressed simply, it's a pro rata apportionment. But things can get a bit more complex. If we move to the next slide. So understanding that you need to be a charity, that that those public interest considerations should constantly be in the back of your mind, and also that the building itself must be used solely for a charitable purpose, or part of it solely for a charitable purpose, in order to claim a zero rate in relation to that element. Keep these ideas, keep these thoughts about the tax in your mind as you're planning, because it can make a big difference. I'm going to talk about annexes as an illustration, because with an annex, if you get it right, the whole of an annex can be exempt from VAT or attract VAT at the zero rate, meaning that no VAT is payable. But on the other hand, if you construct an extension to an existing building, then you're going to attract VAT at the standard rate. And I'll talk through some of the complexities of all of this. But I think what they hopefully serve to illustrate is that sometimes, just by thinking about the tax consequences of what you're proposing to do and getting appropriate advice if it's complex, you can achieve a very similar aim or a very similar end without paying VAT. And on the other hand, if you don't think about it and simply extend, you can suddenly find that you've got a very large VAT bill that otherwise you wouldn't have had to pay. And this is not tax avoidance. It's just forward thinking, forward planning, and getting the appropriate advice when you need it. So in summary, the benefit for a school of building a sports complex or a science block is that there is potential to zero rate both the grant and supplies in the course of that construction. If, on the other hand, you're not building something from scratch, but you're building an annex, so where the whole or the part of an annex is intended to be used for a relevant charitable purpose, for a school's purpose, provided it's capable of functioning independently from any existing building, and it's the access to the annex is not through an existing building, and the access to the existing building is not via the annex, then you can attract the zero rate. And bearing in mind some of these buildings can cost millions of pounds, that's a very significant saving. So ensuring that what you're constructing does qualify as an annex, and there's no statutory definition, although there is some helpful HMRC guidance, you can save substantial tax just by thinking ahead. If we move on to the next slide, it illustrates the contrast. So to meet the requirements of an annex, it has to be attached to an existing building, but not in such a way that it's an extension to that building. And it has to be for activities distinct from, but associated with, the activities carried out in the existing building. So for example, if you've got a sports hall with facilities for five-a-side football, and you want to build an adjacent a badminton court, perhaps with a different surface, and it's attached to that existing building, but you're able to access it independently, both buildings are accessible independently, it will qualify as an annex, provided it's attached to the existing building, and therefore you will not have to pay VAT at the standard rate. They have to be separate parts of the building, and they have to operate independent of each other. So it's every case turns on its facts, but by looking at the law carefully, you can ensure that those investments you're making do not attract tax, do not attract VAT at the standard rate. Moving on to the next slide. So this is the risk. So if you aren't aware of the tax implications and you simply enlarge an existing building, so for example, you knock down the walls of your existing five-a-side football pitch that's indoors, and you don't change the surface, but you create an area where people can play badminton, and you're making the existing building bigger to provide extra space for those activities already carried out in the existing building. So these are sports activities. You're just enlarging to increase the range of what you can do and the number of people who are enjoying that facility. It's going to qualify as an enlargement or an extension. And it may seem very unreasonable, it may seem quite unfair, but an extension or an enlargement does attract VAT at the standard rate. So that immediately whops up your costs, and it can make the cost of that additional building prohibitive in some cases. So the only exclusion when an enlargement or an extension can attract tax at the zero rate is if it's a dwelling. But any other building that a school is likely to construct, an enlargement or extension will not attract tax at the zero rate. It will be the standard rate. So if we move on to the next slide. So the main points really are think ahead, take advice if you need it. If you can see that there is scope to construct an annex rather than an extension or an enlargement, think about the financial advantages of that. Consider, are we meeting the tests? And in particular, with the annex, is it going to be used solely for a relevant charitable purpose? And also consider, you're sitting down with an architect, and these interactions can be quite exciting, looking at plans, and people get creative, but do think about those requirements that you need, which sometimes are really quite subtle. Is it capable? Is the annex capable of functioning independently from the existing building? And sometimes the most minor tweaks to a design can make that difference, and therefore save you a great deal of expense. Is it possible for the activities in the annex to be carried on without reliance on the existing building? Again, that's one of the key tests. And do they each have their own independent main access, both the original building and the new annex? The access to the annex cannot be through the existing building, and you cannot access the existing building through the new annex. So think very carefully about access. And again, a simple matter of putting a door in a different place can make millions of pounds worth of difference in terms of your potential tax exposures. And think about those services that are made in the course of the construction of the building and the work on the building itself prior to the completion of the building, and any services closely connected with that aren't specifically prohibited. So all of those services, provided you get the design right, and you work with your architect to make sure that you're meeting these requirements for the Taxes Acts, can save you both the VAT on the cost of the construction, and also those services are so closely associated with it, unfortunately excluding the costs of the surveyor and the architect themselves. I'll move on to one or two other matters, just touch on them lightly on the next slide. Again, the importance of thinking about your charitable status, maintaining your charitable status and maintaining it in relation to the building that you're potentially going to dispose of, provided a charitable gain accrues to a charity and meets the necessary requirements, it's not going to be liable to capital gains tax. So that's another advantage to thinking carefully about what you're doing, your status and the nature of your construction. And the final slide just touches on stamp duty land tax. So again, provided the building or provide the land, if you're needing to buy additional land, perhaps adjacent land to place your annex on, it may be that your existing sports facilities are on the edge of your plot and you need to buy additional land to build an annex. You must intend to use that land for the qualifying charitable purpose, and then you will attract charities relief from a stamp duty land tax or a land transaction tax in Wales perspective. And this is really important as well because, you know, stamp duty land tax on land for development, we can be talking about very large liabilities. So again, these are just additional features to think about in addition to the VAT. But I really can't urge you strongly enough that to think ahead, think about the potential tax implications, get creative when you're working with architects and thinking about developments and investments in new structures, but bear in mind the potential tax implications because it can save you a fortune. And some of the adjustments that you can make will enable you to achieve a very similar end just by tweaking things a little, things like access and ensuring that you qualify as an annex and you are adjoining, for example, can actually make a very significant financial saving. And so clearly there's some really good opportunities here, provided you're alive to what they are. I'll hand you over to Colin, who wants to continue this session.
Thanks, Sarah. Thank you for that. My name is Colin James. I'm a partner in the construction engineering team. As Sarah said, school projects can attract zero rates of VAT in many circumstances, depending on the nature of the building, future use, and the services being carried out. And in our team, we have a lot of experience advising colleges, bodies of further and higher education, as well as plenty of schools on projects where for VAT, commercial or other reasons, the procurement strategy for the school is to procure the relevant construction services, works and materials via a trading company. As well as for tax reasons, this can simply be because sometimes the permitted activities of the school don't allow it to construct directly, and so the use of a trading arm for tax or other reasons or charity reasons is necessary. If we can go into my next slides, please. And it's this situation which I have some points to flag. So in the scenario here, school enters into an agreement, a services agreement, development agreement with its trading company, which in turn then contracts for the advice, design services, as well as construction work. So many reasons why this model of procurement may be used. Use of a trading company could give easier access to insurance, but also, of course, the school is then shielded in this structure in the event of disputes or claims, which can always arise. And if we can go on to my next slide, please. And one of the primary reasons for that is principle of privity of contract, which broadly says that only the parties to a contract have rights and obligations under that contract. So in my scenario, building company, building contractor with a claim for additional payment brings that claim against the trading company, not against the school. And so the school in that sense gets a degree of protection. But of course, that works in reverse. So in terms of considering the rights of the school, if say building defects were to arise at some later stage, whether that is design related or construction related, the school will only have rights under the contract to which it's a party. So a range of issues for the school to consider as the ultimate proprietor of the project, and does it want to be left solely with the right to bring a claim against its own trading company? How can this be covered? If we go on to my next slide, let's have a look, shall we, at the terms of a sort of development and construction services agreement, which can be quite integral to the VAT recovery strategy. because the advice of the revenue may be or given is that you can contract in this way, but very typically the revenue will be looking to see that this is set up as a genuine commercial arrangement under which there are clear obligations and also entitlements, and the school isn't simply using its trading company as some sort of sham protection arrangement. So in terms of the contents, I'm not going to go through all of my headings there, which are just examples. The trading company undertakes to complete the design and also to procure the work, so the school gets a single point of responsibility for the delivery of the project. The trading company takes on the appointments of the professional team and contractor, and also looks to discharge any relevant statutory or regulatory consents, planning, and so on. And there's one particular set of regulations very important to construction, which is the Construction Design and Management Regulations 2015, which apply to pretty much all forms of construction work with criminal sanctions for non-compliance. The aim with these regulations are to manage how health, safety, and welfare risks are dealt with on a site in the pre and post-construction stage, as well as ongoing later use and maintenance. All parties to a project will have their own obligations under the regulations. And in terms of the client's duties, those will include to put arrangements in place to ensure that health and safety is properly accounted for. Key characters have to be engaged, a principal designer, principal contractor, and works of any duration. The client's obligations will be to notify that project to the health and safety executive before work can start on the site. And in my scenario, where the school is using a trading company to deliver those works, technically you have two clients there because neither of those characters are actually undertaking any works, as the regulation says that between them they have to elect one of them to be the sole client. I'm not going to cover all these points in great detail, but other considerations are intellectual property, ownership of designs which are produced. Also, the revenue will be looking to see that there is a fee or some profit element for the trading company in order to demonstrate this is a genuine commercial transaction. So it's not a simple pass-through of the cost. Other factors to consider will be how practical completion and sign-off of the works is to be dealt with. And also insurances are very important. Construction comes with always a degree of risk. So there will be insurances to cover against the risk of personal injury or worse, and damage also to other property, of course, including potentially other existing structures on the site if this is an extension project or an annex. So just moving on from that to my next slide, please. What the school, though, should be looking to is not just relying upon the development agreement. It should be best advised to secure its own rights to bring a claim if it has to. And this can often be provided by way of what are called collateral warranties, warranties which are essentially collateral to another one, the building contract or the professional team appointment. And the purpose of these is to effectively give a contractual link between those responsible for the design and construction of the work and a relevant third party. In my example, that would be the school, but it equally could be a bank or some other funding institution. And as an alternative to warranties, the other route available is given under what's called the Contract Right of Third Parties Act, whereby express third-party rights can be written into the building contract or the consultant appointment for the benefit of third parties. And with the benefit of either a warranty or a third-party right, the beneficiary school would hope to have its own direct right of action my next slide, please, if someone can just tick that on. Thank you very much. In terms of my structure, my lines here just are showing how fill that gap. And if we go on to my next slide, another primary reason that this is important is that because in English law, claims for breach of contract in the building context usually is based on the idea of claiming for the financial losses which arise of putting something right, putting a defect right, or something which is related. That's categorized in English law as a claim for economic loss. And to make a claim for economic loss in English law, you need a contract, you need a contractual relationship for that to happen. So it's important to give consideration in that regard. There's a further consideration, which is that it's always important to ensure that your claim gets all the way through the various hoops which have to be followed. Claims for building defects are invariably going to be based on a claim for a breach of contract by the contractor or possibly one of the consultants. There's two parts to making such a claim. First, to establish that there has been a breach in the first place, which means looking at the express services and other obligations under the relevant contract, usually backed up by the opinion evidence of a suitably qualified expert. But having established liability, you also then need to show that there was a loss which resulted from that liability. And the general principle in English law is that damages are assessed based on the compensation principle, which is broadly meaning putting the claimant into the position monetarily that it should have been in had that contract not been breached in the first place. And so you can have a situation where there is a breach, but there may be no loss. And that could arise if, for example, the only party able to make a claim for a problem with a building project is the trading company. And the argument would run the trading company not being the ultimate proprietor and having been paid in full under the development agreement hasn't actually suffered a loss, regardless of any breaches of contract that might have arisen, in which case any damages are going to be nominal, if any. So the school does need, in that scenario, to give itself a direct right of action. There are further considerations depending on the wording of some of the warranty documents and third-party agreements which we sometimes see, because typically under those, the warrantor will be given an entitlement to rely on what's called a same defences line, which is broadly, it can rely upon the same defence to a claim under the warranty to one which would have applied had the claim been brought under the contract to which it's undertaking the works or the services. And if in that scenario a claim is brought by the beneficiary of the warranty, then there's always going to be the risk of a same defences line being, well, I wouldn't have had to pay anything to the trading company because it suffered no loss, therefore I don't have to make any payment of damages under this warranty or third-party right for the benefit of the school. So there's always quite a lot to think about and a lot to work through. But as one general message here is that if the advice is tax advice can be that you can use this structure, you've got to follow it through and actually follow it. So you can craft all this wonderful documentation, but in practice, you need to deliver on how the advice has been set up for you. And we'd be very happy to take you through that. Thank you. Lots to think about. And over to the next, Ollie.
Thank you, Colin and Sarah, for that really useful session. Lots of really useful tips for schools when considering construction projects. We've had a couple of questions in that we'll just deal with quickly before we move on to our final session. This first one for Sarah. An interesting question about the charitable status of independent schools. And we've seen, again, recently that has come under some attack, most recently at the Labour Party conference a few weeks ago. How likely is it that the tax treatment of independent schools will change in the event that they lose their charitable status?
Well, at the moment, if the charitable status was simply stripped away from independent schools, then their tax treatment would change immediately and fundamentally. I mean, it's a good question. The most recent analysis I've seen of the tax advantages to the government of stripping away the charitable status of independent schools, I think Keir Starmer was saying it would save the country 1.5 billion a year and would bring in additional tax of 1.5 billion a year. Frankly, I think it's very unlikely to happen. I mean, I don't want to get political, but where are all of these children currently in independent schools going to go? They need to be educated. They can't be educated for free. And I don't know about you, but I haven't noticed any schools, state schools, running empty currently. So that saving of 1.5 billion could easily be consumed by the construction needed and the provision needed to educate these people in the first place. But were it to go and were someone to make that very simplistic decision and arguably not consider those wider costs, then their tax treatment would change immediately and they would become fundamentally different and taxable like any other entity in the UK, and all those protections that they've enjoyed that have made independent schools possible in many cases would be lost.
Thanks, Sarah. Yeah, certainly an issue that I think is going to remain on the radar of independent schools. And one quick question for you, Colin, before we move on. What measures are contractors taking to manage risk in relation to COVID amongst their personnel and in terms of what their people might be bringing onto school sites?
It's been a big topic for the past 18 months. First of all, a bit of a myth that government legislated against construction because of COVID. It didn't. It loved the idea of people carrying on an element of the economy outside. It broadly said, if you're going to undertake construction, here's some guidance about operating safely. And that's quite an important point, because some contracts will say that a contractor will have an entitlement to extra time or extra money if there is a statutory regulation to do with how that work is undertaken. Government has never statuted against construction. It simply said act safely. And there's a vast amount of guidance which has been issued. And if you go to any construction site, there will be a great deal being done to ensure health, safety and welfare. One other key point is, if you are a school with contractors coming onto your site, control. It's your system. It's your health and safety policy that needs to lead. And it's very important to bear that in mind. And so don't forget, it's not that contractors can come and do what they want. They have to work with you. And so if you have a policy, their system, their ways of working need to work with you.
Absolutely. Thank you very much, Colin, and thank you, Sarah. So we're going to move on now, and last but no means least, I'm delighted to introduce Emma Swann, who's a partner in the team and our head of academies, and Coral Putrell, who is a solicitor in the team, both of whom work with schools exclusively. And Emma and Coral are going to talk to us now about all things commercial. So over to you, Emma.
Good morning, everyone, and thank you, Ollie. Could we move now to the next slide, please? Thank you. So today, as Ollie has mentioned, I'm going to be focusing on commercial contracts, looking at what we would expect to see when you're negotiating a contract, and also giving some tips on what to do where things go wrong. Now, as I'm sure you will appreciate, there are obviously a wide range of contracts that your school may enter into. So this presentation today is relevant whether your school is purchasing services, so I'm thinking here cleaning, catering, transport, providing services, potentially by means of a hire agreement, or also if you're entering into other more bespoke agreements, so be it a grant agreement or perhaps a collaborative agreement with other schools. Can we move now to the next slide, please? So the first area that we're going to look at today is what is commonly known as the battle of forms. Now, essentially the question here is which terms are going to prevail. Now, your school, as a party to a contract, can decide to agree a bespoke contract. This may be relevant for more complex agreements, but alongside this, each party may have their own standard set of terms and conditions for, say, the supply or purchase of goods or services. And we would always recommend that you have those in place. So what does this mean? How does this work in practice? Well, if, say, a supplier offers to contract on its own terms and your school accepts, but then puts forward your own terms, your school will be considered to be making a counter offer. If the supplier then provides those services without actually addressing the issue, it's deemed to have accepted your school's counteroffer. And as a buyer, your school will effectively have fired the last shot and won the battle of the forms. So your terms will prevail. Can we move on now, please, to the next slide? Thank you. So I'm just going to look here at the parties to a contract. Now, I appreciate often you're going to think, well, this is really obvious. It's going to be your school, say, perhaps an academy trust or a charitable company, but that isn't always going to be the case. And I think Colin helpfully alluded to this earlier. Sometimes you need to think through who will be the correct party. So there may be some situations where the contract should actually be entered into by a trading subsidiary. This could be particularly where the purposes of the contract sit outside of your charitable purposes. Also, it can be for tax reasons and to reallocate risk. Now, it is one thing I would flag up, however, this is something that needs to be carefully thought about. We've come across situations, say, if you have perhaps some grant funding in place, it may actually be a condition of your school's grant funding that the funding remains with the school and it cannot be transferred. Now, we've actually seen some major projects get into difficulty over this if the intention was to transfer funds to a trading subsidiary. So it's something that I just flag up that it's sensible to think through at the outset. It's also, of course, important to be clear who your school is contracting with and to carry out any due diligence that's needed as appropriate. Can we move on now to the next slide? Thank you. So one area that I would just like to look at that you may come across in your contract is an endeavours clause. Now, usually contractual obligations are absolute, and consequently a failure to comply will result in a breach of contract. Endeavours clauses basically allow your school more wiggle room. So it could be used where a party is only prepared to try to fulfill an obligation rather than to commit to it absolutely. So what should you be aware of at school? Well, firstly, there's a spectrum of endeavours clauses, with best endeavours being a much stronger obligation than reasonable endeavours. For any endeavours clause to be enforceable, there must be certainty. And to avoid dispute, what we would actually suggest you think about is that it's worth actually clarifying any required steps between the parties so that everyone knows what is actually expected. Can we move now to the next slide? So here I'm looking in particular at best endeavours. Now, for a best endeavours clause, your school would be expected to, or would expect a supplier to, take all those steps in their power which are capable of producing the desired results. So all those steps are the critical words here. Best endeavours may therefore require some expenditure. It could impose an obligation to perhaps litigate or appeal a decision. And it may, in some circumstances, actually mean sacrificing your own commercial interests. Can we move now to the next slide, please? So here I'm looking at reasonable endeavours. Now, a reasonable endeavours clause, as I've indicated, is essentially less burdensome. So to comply with such a clause, a party may only be required to take one reasonable course of action. And crucially, there's not normally a requirement for a party to sacrifice their own commercial interests. Now, sometimes it may be the case that you're trying to negotiate between these two and you're finding it difficult to reach agreement. If that is the case, one suggestion is that there's an all reasonable endeavours clause, which is effectively a compromise. So it sits somewhere between the two. Can we move now to the next slide? Thank you. So I'm going to come on briefly to force majeure. This is obviously a clause that has received a lot coverage over the past year. So I'm sure you're going to be relatively familiar with this. Now, a force majeure clause will set out any events or circumstances which are beyond the reasonable control of a party. Now, in circumstances where a force majeure event occurs, if the party affected will be excused from performance of the contract during that time. Now, this has obviously hit the headlines over the past 18 months because of COVID and the pandemic and the impact that that has had on the implementation of contracts. Can we move on, please, to the next slide? So what would we actually say to you? Well, it's an important clause to have in a contract if it's correctly drafted. Now, force majeure itself has no recognised meaning in English law, and it should therefore only be used where it's properly defined. Now, for example, a provision that states the usual force majeure clauses shall apply will be void because of uncertainty. What I want to see is that a force majeure clause comprehensively lists situations that may occur and impact on the performance of your contract. So I'm thinking here specifically of COVID, referencing that within this clause, and also having a wrap-up catch-all provision. You also, in force majeure clauses, need to consider carefully the notice provisions, and Coral is going to come on to notice clauses in more detail later. And you should also consider whether a force majeure event may allow for termination of the contract. Now, how we would draft a clause, how we would suggest that you draft it, depends on whether the school is more likely to revoke that clause or the other party. Can we move on now to the next slide, please? So the final area that I'm going to look at today is limitation of liability. This is obviously critical, particularly where things are going wrong in your contract and you're potentially looking at termination. So as a starting point, what I would say that you should be aware of is that the parties to a contract can never exclude liability for fraud or fraudulent misrepresentation, also for injury or death caused by negligence. It is, however, standard in a contract to exclude certain indirect losses. So you may, for example, exclude loss of profit or goodwill. Now, in order to limit your potential risk, what I would suggest that you consider is imposing a cap on liability in respect of a claim. This could perhaps be related to the contract price. However, it's really important that you have clarity here. So does that, for example, relate to one claim or all claims? Does it essentially cover your school's entire liability? Now, for these sort of clauses, it's worth being aware that the court generally allows parties to negotiate, and it won't intervene even if it seemed to be a bad bargain. Now, one other approach that I would just flag up that I think is also worth considering including is a liquidated damages clause. This is slightly different in that it fixes the amount that would be payable in the event of a breach. So essentially, it's a reasonable assessment of losses that you're coming to at the outset of the contract. Now, the only thing that I will flag up here is this hinges on reasonableness, and you don't want to stray into the territory of a penalty clause, which will be where the amount stated is deemed to be extravagant, and in those sort of circumstances, that will be held by the courts to be void. I'm now going to move on at this point and hand over to my colleague Coral, who is going to talk to you about termination. Thank you.
Thanks, Emma. So whilst we always hope that things will go smoothly, sometimes it doesn't work out. And the relationship between the school and the other party to the contract can break down. If this happens, the school will want to understand the situations in which it can terminate the contract and the provisions for service of notice to terminate. Next slide, please. When it comes to termination, it's important to know that there is always a right at law to terminate for very serious breaches, and there is no need for this right to be expressly set out in the contract. Contractually, however, we would expect the contract to include termination for material breach, where the breach cannot be remedied within a certain timescale, and termination for persistent breaches, which is often the easier of the two to prove. It's also sensible to include a right to terminate for convenience with notice, which would mean that the school could terminate without reason and without having to prove any breach, but may have to give, for example, 3 months' notice. Some other express provisions which can be included for peace of mind include termination and change of control of either party and termination on insolvency. Next slide, please. So once you've considered whether the school is in a position to terminate the contract, you should consider the requirements in terms of service of notice. Notice provisions in the contract should avoid being overly prescriptive, but should make it clear exactly what steps will need to be taken to successfully serve notice. The contract should set out how much notice needs to be given, for example, 3 months, as well as confirming that a notice should be given in writing. It's also key that where timescales are related to business days, that a business day is defined within the contract. This could be, for example, a weekday other than a bank holiday or weekend in England and Wales. Acceptable delivery methods must also be confirmed, and consideration should be given as to whether email will be a permitted method of delivery. The parties will also need to know when a notice is deemed to be delivered. For example, if sent by post, it might be 9 AM on the second business day after posting, or at the point of delivery of an email. Next slide, please. If your school finds itself in a position where it needs to serve notice, you should initially check the contract for a few points. Check how the notice should be delivered, check whether there's a specified address or recipient for delivery, and check when the notice is deemed delivered. You should also consider retaining evidence of delivering the notice, such as a photo of the notice being posted with the address visible, or an email with the notice attached in the sent box of the appropriate email account. So that wraps up the top tips and considerations in respect of commercial contracts which your school may enter into. I'm just going to move on to give a whistle-stop tour of a consultation in respect of competition and consumer law, which was launched earlier this year. Next slide, please. So the consultation was launched on 20th of July this year, focusing on reforming the Competition Market Authority's enforcement powers, introducing fines for breach of competition regulation, and strengthening consumer alternative dispute resolution. This will be relevant to your school where you, for example, enter into hire agreements for the hire of sports facilities to third parties, where you allow use of classrooms outside of school hours for a fee, and of course, where you enter into contracts with parents. Next slide, please. So part of the consultation is to consider granting the CMA stronger enforcement powers. It's been proposed to introduce stronger interim measures, for example, changing the rules regarding access to files so that the CMA need only provide notice of the proposed decision and reasons, rather than access to the whole file of evidence. In addition, voluntary resolution procedures are proposed to be strengthened, including use of agreements between the CMA and schools. The school may make binding admissions of facts or liability to streamline the investigation process and bring it to a conclusion sooner. Independent schools will be aware that the CMA has not been hesitant to intervene, as the consultation follows on from the April 2020 letter warning that agreeing prices or exchanging commercially sensitive information on future pricing or business strategies with competitors will not be tolerated. Next slide, please. As well as giving the CMA more powers in terms of investigation, there are plans to enhance the sanctions which can be imposed on any school by the CMA. This could include fines of up to 10% of turnover for schools that breach consumer protection law, and additional sanctions for schools which frustrate, delay, or otherwise are non-compliant with enforcement process, including flouting information gathering powers and breaching undertakings. Next slide, please. Whilst the proposals mentioned so far relate to public enforcement, most complaints are individual in nature, and parents must understand the redress options which are available to them, including ADR. In accordance with the consultation, it's proposed that ADR will no longer be seen as an alternative to court, but will be treated as an integrated part of the justice system. The consultation therefore aims to strengthen and expand the scope of ADR, which will hopefully lead to an increase in the rate of disputes being resolved satisfactorily. To achieve this, parents would be provided with more support to navigate ADR successfully. Next slide, please. So although the consultation has now closed, schools should still take steps to ensure that your practices align with competition law and consider how these changes may impact your school. The CMA is clearly keen to take proactive steps to ensure that any schools in breach of regulations are subject to appropriate enforcement action. This will be important to consider and keep an eye on, just as with the new GDPR, particularly given that fines for breach could mirror those which can be enforced for breach of GDPR. So that wraps up our commercial presentation for you. So we'll just open for any questions if you have any.
Thank you, Coral and Emma. That's great. Some really important points there, I think, to understand when you're negotiating and entering into commercial contracts. It's a particularly tricky area, so please do contact Emma and her team should you need any support. So that brings a close to our session this morning. I'm conscious we're coming up to 11 o'clock and that we've covered a lot of ground already in a fairly short space of time. So if you have any follow-up questions, please do get in contact with us. From all of us here at HCR, thank you for your engagement and your involvement today. It's great to have your questions, and although we can't see you, it's good to know that there are a number of familiar faces there. One topic we haven't covered this morning that I'm sure has been on your radar is the new Keeping Children Safe in Education, which was introduced in September. The reason for that is we have a session dedicated to it on the 11th of November, so please do sign up for that if you can. Our next webinar is on the 20th of October, next Wednesday, when we'll be looking at obligations towards pupils under the Equality Act. And we'll send a follow-up email to you with the slides from this morning's session and the full programme of our autumn term events for your reference. As always, if there are any other topics that you would like us to cover in terms of events, do let us know. We really value your input. But otherwise, we're just coming up to 11 o'clock now. So thank you as ever for your support and enjoy the rest of your day. Thank you.